Hello friends, how are you? Har Har Mahadev, Jai Shiv Shambhu. Myself is Dr. Jinesh Soni. I am an advocate and a defense counsel. In today's class, I will discuss about section 49 of BNS along with section 61 subclause 2 of BNS because both these sections in nowadays are going to be used by CBI or by ACB. So whenever you see all these sections, means section 49 of BNS or section 61 subclause 2 of BNS, the important point arises how to contest them because in case we are innocent. But inter alia, these sections are on file. With the help of these sections, the concerned prosecution even pray to the Honorable Court to convict us. So basically, we have to understand the conceptual perspective so that we could understand our rule, we could understand the factual perspective, and could easily encounter the allegation as I specified you earlier. I request all of you to maintain a proper notebook with pen or pencil. First of all, we will understand the conceptual difference between both these sections. Section 49 of BNS is concerned with abetment. Please be noted, it is concerned with abetment. When a public servant commits corruption, there might be allegation of like nature against the public servant. There might be a possibility that a third party, means another person, inter alia instigated or helped the public servant or inter alia enter into conspiracy with him to commit the offense. Basically or collectively, it is called the abetment. In that scenario, if the offense is committed, the concerned person who is going to abet the offense could be prosecuted along with the public servant. So, in a nutshell, we could say that if the offense is committed in consequence of abetment, not only the public servant but also the abetter would be liable. But abetter would be liable as per section 49 of BNS. Now I am coming on criminal conspiracy. Section 61 subclause 2 of BNS inter alia provide punishment for criminal conspiracy. Now the important question arises, what is criminal conspiracy? When two or more than two persons. So basically 2 persons are required. But there is no requirement of 2 persons in case of abetment. Please be noted. So when 2 or more than 2 persons agree to commit corruption or agree to commit the criminal activity, the agreement itself is punishable. Please be noted, actual execution of the crime or corruption is not sine qua non, means requirement. So basically we could say that a criminal conspiracy is independent substantive offense. Now the question arises, how these sections are used by Anti-Corruption Bureau in anti-corruption cases. So basically, as far as section 49 of BNS is concerned, they may apply the same with allegation that the concerned persons, means the third party, inter alia acted as a middleman or as an agent or as a clerk, or he might be relative or friend of the concerned public servant. So basically, there might be allegation that the concerned person inter alia helped the public servant to take the bribe. So basically, whenever you are going to read the file, you have to find out what intentional help has been given by you to the concerned public servant. If the ingredient of abetment is not on record, the allegations are general or omnibus, we could have the benefit. Please be noted. In addition to this, we have to find out the actual crime committed by the public servant. If public servant is not in picture, there is no averment against him, and you are prosecuted merely on the basis of section 49 of BNS, in that scenario, entire proceeding would be illegal. So, in nutshell, we could say that the main offense is required to be committed. In absence of main offense, no accused could be prosecuted for abetment as per section 49 of BNS. So simply we could say that in a nutshell, defense line, without proof of the main offense, the prosecution of the co-accused, means the third party, as per section 49 of BNS would be illegal. Now the important question arises, how the sections of criminal conspiracy is inter alia applied by CBI or anti-corruption. Basically, when the case of prosecution is quite weak, so with the help of criminal conspiracy, they try to file the charge sheet before the competent court against the public servant. So in that scenario, the entire target is the public servant, not you. But you are also required so that he could be prosecuted, and that's why they used to apply the charges of criminal conspiracy. So basically, whenever you are going to read the file, you have to see what is meeting of mind, and apart from that, what are the evidences by the virtue of which the conclusion of conspiracy could be derived. If the allegations are vague, there is no specification, then we could be succeeded. But we have to study the entire file to draw the effective conclusion. So, in simple word, we could say that the application of both the sections are different, but usually these sections are applied by the concerned anti-corruption bureau or by CBI so that the accused could be charge sheeted easily. So, concerning section 49 of BNS, the prime strategic defense argument is that there is no evidence on record that the alleged main offense has been committed by the public servant. Even the argument might be that the public servant has not been prosecuted. So, in absence of public servant, and if the main offense is not committed, the concerned accused means the co-accused means the third party could not be prosecuted with the help of section 49 of BNS. To attract the prosecution and conviction, it is required to show that the main offense has been committed. If the main offense is not committed, the charge of section 49 of BNS would collapse. Apart from that, as far as section 61 subclause 2 of BNS is concerned, the material must be on record to show that there is prior meeting or prior agreement. Mere suspicion cannot take place of proof of conspiracy. So, whenever these sections are inserted, there is no need to worry. Just read the file and find out your role so that, in light of factual score, your exit role, if not specified or not specific, and allegations are general and omnibus, you could easily get the benefit. So, things are not difficult. It depends upon us in which manner we are going to contest. See you in the next video. Till then, Jai Hind, Jai Bharat.